later on. So let me also start by introducing myself. I'm Barbara Warwas. I'm a lector, which translates into the professor of practice in multi-level regulation and dispute resolution at the Hague University of Applied Sciences at the Center of Expertise on Global Governance. And I will also explain to you a little. I'm a lector, which translates the professor. If I could ask all of you to, yes, mute yourself, that would be great. Yeah, I will also explain to you a little bit what in fact applied research is, because I would like to engage with in this at the start, and then we will go through a number of questions and points. What I would like to start with is that legal research is very often underestimated, I feel, by students too, especially legal research skills. We kind of all think that everyone can do research, everyone can do legal research, and we think that we can do this whenever we want, which is of course true. But how to do this well is a whole different discussion. And I hope to provide you with some practical tips, because there are some tips that can help everyone do research and provide legal framework also for research. So I realize that you are part of the debate club, so to say, but this presentation also serves in general for you to understand how to engage with legal writing, how to engage with legal research in the context of your assignments and many different products that you have to provide in the course of your studies. So we will start by discussing the types of legal research, especially here in the Netherlands. And I'm also curious what your perception of this is. Then we will speak about the research design, and we will conclude with the research methodology, which is also part of a research design. And then if you have any questions, we will move towards them. So you might know, I hope you do, that you are studying at the University of Applied Sciences. So I first wanted to kick off with a question to you. What does it mean to you that you study at the University of Applied Sciences in terms of the legal research that you do? If anyone would like to raise their hand or respond or write in the chat, what is so different about these applied sciences? Gustavo.
I can give it a try. So I guess there are two different kinds of universities. You have the applied science and the research university. So I think in applied science university, the kind of research you have to do is the research that allows you to solve practical problems and be more efficient in that sense. But I don't know if I am saying this right.
Yes, that's correct. I would say, because as you can also see on the slide, there is not a single definition. But I think it's important that that you are aware of the differences and how at least this system is structured within the Netherlands. Is there anyone else who would like to complement Gustavo's definition or perception of applied research? Everyone agrees. That's great. So the more like also ice-breaking question, how many universities of applied sciences there are in the Netherlands? Who do you know, maybe?
I'm not entirely sure if I can answer this question, but I can say that we are today mixed audience. I believe we have students from applied sciences here, but we also have students, I see participants from Indian team in the list of participants, and in the live on the YouTube there might be also from other universities. So just to give everyone an idea, we are for those that came late to join in the stream and the call, we are co-hosting this event with an ILSA chapter from The Hague, and our speaker today is Dr. Warwas, who's teaching at the Hague University. So the audience today might be a bit mixed, also students from the Hague University and the participants of the competition.
Thank you, Anna Maria. It's also good for me to know. I was not aware of this, but it's also good to engage others in this discussion and have an open discussion whether there are, in fact, any differences between applied or fundamental research, legal research. I think we had one response that there are 39 universities of applied sciences. To my knowledge, there are 36, but maybe it's quite close. So just it's around 36 per 40. And it's important to realize this, that there is an also association for the universities of applied sciences. Let me go further when it comes to the question of applied research. So applied research is administered or supported in the Netherlands by the task force SIA, which is part of the Netherlands Organization for Scientific Research. And it's financed by the Ministry of Education, Culture and Science in the Netherlands. As defined by this task force for applied research at the universities of applied sciences carry out research which is of course applied and arises from issues or problems in practice. So what Gustavo was saying was more that the research needs to inform the practice, which is correct, but I think for you the most relevant definition would be to know that the professionals very often, if not in most cases, provide their own question that needs to be researched. So applied research is in response to the actual puzzles that are practical puzzles that come from the professional field. And the outcomes of applied research are knowledge, greater understanding, prototypes, products, and services that support innovation in professional practice and the solving of social issues. The research also strengthens the quality of higher vocational education. So that's also important to know that applied research really looks at multidimensional aspects of legal problems. It's not only or always professional field, but it's also society as such that we in applied science universities should be benefiting. Oftentimes also meaning students and oftentimes meaning citizens. So as you see from this list, there is a variety of outputs expected from applied research concerning not only knowledge as such, but also certain practical products like prototypes, toolkits, services, etc. And I'm sure that some of you have done it already at our university and in the law program. Some of you may be doing this in the future, namely engaging in applied products or professional products or questions that come from the professional field. I will also speak about it next when we speak about the research design and research context, but I think it's important to already know or have this definition. What does it mean also to do research in and with practice? This is the most important feature, and the research is always done with the practice. The research covers a wide range of subjects, and is often multidisciplinary. That's quite interesting. When you work with professionals, even when you have a question from the legal professional, it's often the case that you will be engaged in a problem, or you will do research either in a team or even on your own, but you will need to look at the problem from different fields and perspectives, not only law, because if the product or research is supposed to benefit the society, we need to also take into account other disciplines. And just to also give you some hints, at the Center of Expertise of Global Governance, that I am the pleasure to be a director of, we also developed an academy for global governance innovators, and we also invite professionals to ask their questions to students so that students can respond to those questions with professional products. And the last edition, we focused on climate policies and the involvement of youth in climate policies. And we had a question from practitioners concerning how we can improve the governance of youth climate associations. And this question was tackled from many different perspectives. It focused also on SDGs, and it was nice to see that students also from a legal perspective understand the dimension of legal problems from different perspectives. So that's also the feature of applied research. And for you, I think it's also when you are engaging in research, try to also always put it in the context. We will speak about it in the next parts of this presentation. Collaboration is also a very important part of applied research. It means that we as applied science, we collaborate with professionals, with knowledge institution, with public or private partnerships, and this is where the network for those actual legal questions should be at least coming from. As I mentioned, at THULDT we have 7 centers of expertise. I wanted to make you aware of this because even in the context of your legal research now, for your tournament, you can have a look at those centers. If for any question that you are researching concerns any of those questions, I really encourage you, any of those topics mentioned here on the slide regarding centers of expertise, it would be potentially good for you to go to the website of those centers of expertise, see what they are doing, how they may potentially connect with you and how you can connect with them. So of course, I realize you don't have that much time often, but it would be a good platform for you to also seek more information, especially if you would like to engage some professionals in your research. So instead of just emailing yourself people or inviting people for interviews, try to also use the centers of expertise as a platform potentially to help you. And the topics that we cover are as follows: cybersecurity, digital operations and finance, governance of urban transitions, health innovation, global and inclusive learning, global governance, and mission zero. So I think that many topics can be of relevance also for your debate. In law, I suspect global governance can also be of interest, but that can be also just self-promotion. When it comes to fundamental research, there are of course variety of definitions, but the fundamental research in principle focuses on the development of new theories, concepts, doctrines, and the testing of hypotheses or assumptions that arise from the theory. So fundamental research is always considered to be more theoretically oriented, but the differences in definitions and methodology of both applied and fundamental research are being increasingly blurred. Here I again wanted to ask the question to you. In your legal research, from the perspective of you being students at THULDT, I assume most of you are from International and European Law Program, but as I hear, not all of you. What does it mean? What do you think about those differences? Does it make any difference from you as future lawyers or legal professionals, whether research is applied or academic or fundamental, or you don't totally take this into account? Gustavo?
Yeah, I think for me it makes a big difference because you can do your research on in a pure theoretical point of view, which doesn't necessarily have to be applied in practice, but you make like a doctrine or make like some theories, and then if you decide to maybe conduct a research for something more practical, it might be a big difference. I mean, this is what I personally think, but I don't know.
And were you or any of you were you really aware of this distinction before also choosing your studies here, or you just essentially assume that for lawyers it doesn't really matter because for lawyers we always have to engage in practical research? Okay, I leave it open because yeah, maybe okay, Olesia.
Yes, so I personally wasn't really aware of this difference, especially not regarding research. So I think it's very interesting, and I will pay more attention when I'm doing research now, whether it's more like applied or theoretical.
I think it's important to realize this also when you are here in the Netherlands, also regarding your career path, but also how you approach different legal questions, because it always matters what you are doing. And of course, even for specific products, so for a legal thesis, it is considered usually, especially in research universities, that we always engage in this very theoretical research. But I think that today the global challenges and legal practice is so globalized, and it concerns so many topics, and it's so interdisciplinary that we really have to include perspectives from different disciplines too. So it's very important to be aware of this, and also tailor your research, but also look for sources maybe somewhere else. And I hope I will slightly at least help you approach this through this presentation today. So where to start? When you do your legal research, what do you usually do? You can be totally honest and open. I'm sure all of you start with going to Peace Palace Library or other library where you spend weeks to study the topic. But if you don't do that, what do you do? Or maybe you, in fact, do this and go to the library and check. We have another hand, but I don't see the name. So if you could, so I invite the person who raised their hand to, I will turn on the chat. Gustav, sorry, Gustav, I didn't see you.
Yes, so regarding the question, when I do research, what I do first, I just read the title and then I start my research from like, I start looking for information related to the subject, but in a broad perspective. So first first what I do is, for example, try to find all potential sources that are recently and are updated, and start from broad to a specific. So then I just narrow it down till I finally find the source I really have to do. Because sometimes it is, I mean, it really depends the topic you're doing research on, because there might be lots of information and also there might be scarce information in relation to the topic.
Yes, so that's correct, Gustav. It's always good to start reading, but I think it's also good to have a plan. And it's also good to, of course, reading is always very important. It's very important to do research, but we need to know how to start and how much time we have. So, you know, we have to do a little bit of a project management, I would say, in the context of research. And I see that Sarah Jane would also like to share her experience.
Yes, so for example, I first like to define what's the legal problem itself, and then what I've learned from the skills, which at the time I didn't think would be so useful, but I see it's useful now from the university courses, is finding synonyms to this legal problem, because then we're broadening our the searching words, because a lot of times you don't just find exactly what you're looking for, but if you find the synonyms or different ways of formulating the problem, you do find other sources which are still useful within the same context.
That's interesting. Yeah, so you are like reformulating or trying to find different sources for a similar question, but formulated in a different way. Would that be a good summary?
Yes, and also, for example, let's say if you're doing about competition law, you can then find like mergers and acquisitions. So also like certain subtopics related to this main topic.
Yes, and we will also talk about that, because sometimes I think that you are faced with such a broad topic, or when you are starting your own research, you are thinking, oh, okay, I want to do competition law, but it's my passion, or I'm interested in this, but then it's such a deep and broad field that, you know, it's important to be driven by curiosity, but it's also important to be very specific and know what you are doing. So what you are saying is absolutely correct. And also, the more you spend in the search tool, or the more you read, there is so-called snowballing technique, which means that you learn about new things and new terms and phrases, and that also helps you out. But what I would like to say is, for me, what I wanted to, or from my perspective, what I wanted to propose to you is the so-called research design. So research design means essentially that you provide some sort of structure or blueprint for your research, which determines how you will do research. And this concerns a few basic steps. And today I wanted to focus on those basics, which are as follows. First, what is the legal problem? As Sarah Jane also mentioned, what is the, but you know, it's not necessarily what the field is that you are researching, but you really have to understand the more general legal problem and the more specific puzzle that you are trying to address. Also, or the main question that you need to address, and you also have to ask yourself a question: in what context is it asked? So, and I will speak about it in a moment, but it's very important to distill information that you are also researching. And I will also give you some examples. Instead of like focusing on this big competition law, for example, field, you really have to go through certain literature to understand what are the current trends or what the problem is from the perspective of the practice, and what you will be researching upon. And how you do this leads us to step number 2, which means conduct a literature review on the problem. And that's what Gustavo mentioned. You need to learn what other people wrote or said, or what on the problem, or how the legal problem is regulated at many different levels. That's always very helpful. Without that, I would say any research just doesn't make sense. And I would say that it's really the basic and the most underestimated part of legal research, namely the literature review. The step number 3 is to define the main research questions and sub-questions. So once you know this puzzle, and once you know what other people said, or how the legal issue or puzzle is regulated, you are able to define what you will be in fact researching. And you always have to have a very specific research question, which will be defining your whole research. And this is where all your activities aim towards. It's like your finish line. This is what you have to always answer at the very end. And for that reason, it's always very important to formulate this research question in a way that will be answerable, that it's not too broad, in a way that allows you to know exactly what you have to do. And for that, I always advise to have sub-questions, so to have a roadmap for yourself. We will also unfold on those steps a little bit later. Finally, we also have legal methodology that always needs to be defined. And I feel, and when I started doing research, and I have my PhD also from European University Institute, and I have done research in many different research institutes, but frankly, I have to say that for a long while, I was very puzzled about what legal methodology in fact is. And I was treating these, first paragraphs where you explain legal methodology as something that's totally unimportant, but it is very important, because legal methodology concerns the methods, how you do the research. And there are very specific research methods, and I think quite basic also for us lawyers at this stage of doing research, that you can easily learn about. And then I think once you learn about them, it will make your life slightly easier, I hope. Based on all this, part of research design is also legal methodology and legal analysis. And then we also have conclusions that you have to come upon through this, through your research design. I'm really sorry, I'm trying to click quickly on do not disturb, but I always have problems finding this button. So that's, please give me a second. All right, so moving further, we have first step. So unfolding on this legal problem puzzle main question, how to address this. There are different contexts and different examples of how to address the issue. I thought that from your perspective, you will mostly face the three following contexts. For example, when you have certain legal problem that is addressed by your lecturer or in the classroom, or in a debate tournament. So somebody asks you to address some legal question and you have to respond to this. And I gave one question, what is the regulatory framework for online dispute resolution in the EU? Very basic, but it's also like actual legal problem from which you will also have to unfold in certain steps. Then you also have, as in applied research, and especially also at the Hague University now, we have this increasing amount of applied research assignments that come from professional practice. It means that you liaise with some professional, with a company, with a lawyer, and they ask you a question or they give you a problem that they want you to address. It doesn't mean that they give you a research question, but they give you a problem that you always have to unpack. And my feeling is that it's quite complex situation, because then you have usually a few weeks to address the legal problem and also understand the whole regulatory framework and how to address the problem. So example of that would be a company, online dispute resolution company, again, was on my mind today, and asking how to increase our clients' trust in our online dispute resolution system. And after that, you would also need to take certain steps and define your own research question and sub-questions to help the professional answer this question. And finally, there is also a possibility that you are writing a thesis, an essay, a blog post, and in most of these cases, the puzzle also needs to be developed out of your own interests or curiosity. And then my impression is that it's always quite general, that you are interested in something. When I talk to students, they say, oh, I'm really interested in EU law, or I'm really interested in commercial law. But then that's very general, but it's good to be curious and interested. But for you, I want to stress that you always have to have a more specific puzzle. So a legal problem that is concrete and that is a little bit more unpacked than the field only that you are looking into. And how you define this is also the first step. And this is also very, you in your professional life also in the future, I assume you will be facing different contexts for legal research and legal analysis that will be needed or asked from you. And it would, to give you an example, I worked while in the UK, I worked at the Brunel University on the study on the law and practice of arbitration for the European Parliament. So European Parliament a few years back commissioned or published a tender in which we participated as a Brunel team of researchers for a study on law and practice of arbitration, because the European Parliament was considering back then to initiate some regulatory changes in how arbitration and dispute resolution in Europe was regulated. And they totally, who consists, European Parliament consists of whom? Of European parliamentarians, which are usually not lawyers, or in some regards they are, but not in majority. So we had a very clear target audience, European parliamentarians that ask a question that they want to learn about what is happening in the field of arbitration in all member states and at the European level. And knowing the context, knowing who is asking you to do legal research, and knowing that there are different audiences for your legal research, it largely it all determines your research design. It also determines to some extent the sources you have to go through, because if somebody is interested, asks you to do research on law, you of course go through the legal provisions. You do the state of the art of legal provisions. If somebody asks you more about, if somebody is a citizen and asks you for legal advice in the context of a legal clinic, you will need to work on the legal question, of course, still going through sources, but adjusting your language also to in a way that will be understood also by a citizen who asks you for advice. So in sum, regarding this step one, what I'm trying to tell you is that legal problems are always determined or dependent on who is asking, who is posing questions regarding legal problems, where those questions come from, and what your audience is. And please do take it into account when in your research design and when deciding how to start conducting your research. Do you have any questions, or is something unclear, or you would like more information at this stage?
For me, it's really clear, but I don't know if people from the public will have, if it's clear for them.
Yes, it's really basic, but I think it's important to point to these issues. But, in case you have questions, always raise your hand. Second, step number 2 is also how to engage with sources and what is a literature review. And I already gave part of this presentation to students who participated in our Academy for Global Governance Innovators to also make them aware how to conduct literature review. And these slides on literature review that follow after slide number 11 are also based on academic article on how to do a research literature review, and I encourage each of you to also have a look at this article because it is really a good source of understanding how to start reading, essentially. So what is a literature review? A literature review summarizes and sometimes also evaluates the state of knowledge or practice on a particular subject. I gave you a link to the very long literature review that I conducted back in 2016, again on the state of research on arbitration and EU law. And please follow this link just to understand. I was trying to do this, but of course my IT skills are not always perfect. It would be good that, yes, have a look and have some sort of model of how literature review may look like. What are the goals of a literature review? First of all, it can give you a very general overview of a body of research within which you are not, with which you are not familiar. So no matter what the understanding purpose of the literature review is, you always need to know what has been done so far on the topic. When you get a topic and when you prepare for your debate, you always have to have this understanding of what has already been said, what are the arguments on specific legal problem or legal issue, and you always should check the arguments for and against. And there are always people who have different opinions and will have different opinions. And understanding what has been done, it's really the start of every research. And essentially what you have to do for start of any legal research, you have to revise what has been done and create for yourself also a roadmap. Okay, he or she said that, this regulation says that, and there are potential gaps. So in fact, literature review can reveal what has already been done so that you don't waste time reinventing the wheel. So maybe you have some idea, but somebody already had this idea. So it's also very important that you know and can cite to authorities, even if you had similar idea, then you can at least have, you can demonstrate that it is substantiated by someone else's argument. This is called state of the art. So what has been done, on what has been researched, what is also part of the professional know-how, including laws and regulations. It's often called the state of the art. Literature review can give you new ideas that you can use in your own research. It can help you determine where the problems are or flaws in existing research are, and it can enable you to place your research in a larger context so that you can show what new conclusions might result from your research. So these are essentially the goals of sitting down and reviewing literature in the context of your legal research. And essentially, it's a very descriptive task. It's usually a very concise summary of the findings or claims that have emerged from prior research on a subject. For example, you have a table with references to the source and description of the main argument. And here you have an example of this from the article of my own that I included the link to. You can see that table 1 concerns the topic arbitration and EU law, concerning especially EU competencies and harmonization. And here you have a table, which at least I created for the purpose of this research, where I wanted to know from in specific period of time. So I put year, and you start with 94, which is actually where the research on harmonization and arbitration and EU law started, because before there were not too many sources or people were not discussing this. And you go after year by year, and you try to understand what were the major developments and how at least I structure this, and I model this on a very similar literature review. You just start with a title, authors, objectives. So what was in fact the goal of the article and what were the results. And having this gives you a very concise understanding of what has been done in the past, and it can also be a very useful data set or resource set, because you can quickly look, even if you go for your debate, you can have those sources and have the citations ready at hand. So I really always encourage you to start any literature review with something as simple as a table of this sort, and just depending on what you need to look into, you can adjust this table and add new aspects. So that's the concluding summary, concise summary of findings. But then there is usually also a concluding part where you put those sources in some sort of narrative. So you say, okay, based on this topic, here are the following conclusions, or we can group those sources against the following topics, against the following observations, etc. And it's always important to do these groupings, because based on that you can identify indeed all these lines of research so far, all the arguments, and then you can also identify the gaps. Sometimes, but not always, and I have to say that I'm always against students doing this last part, but there is also an evaluative part concerning your own reflections on the literature that you have reviewed. And I think maybe for your debate tournament, it would also be an interesting part actually for you, where you put those sources in the context for yourself. There are different contexts of literature review. So here I put 3. First of all, the first context can be that you have to do just a self-standing state of the art. So you just have to very quickly summarize what has been done so far. So for example, if you have a legal problem that was asked by a professional who asks you to provide certain legal analysis and do research, then you would really start with this state of the art, so that you first can understand what is going on in the topic. I see Emmanuel has a question.
Yes, I have a question. When does your opinion your opinion gets like it's a problem? You know, when your opinion gets in the way of giving a good answer.
You mean when you are evaluating the sources?
Yes.
Yeah, so that's, I think you always have to have your own opinion, and part of legal analysis is to understand and put the context into question, but I would always be very careful in giving your own opinion about the source itself. I would only focus on the arguments and see how, you know, the argument is engaged with, whether it's supported by sources. I would suggest to evaluate the argument also based on types of sources that are used, because if somebody has an opinion based on internet and Wikipedia and sources that are not necessarily primary sources, you can always argue with that. So I would always focus on the content and put the arguments, give your opinion in terms of weighing the arguments on some very objective grounds, I would say. Does that answer your question, or it's?
No, it's more about when your opinion is based in like objective information, but I don't know. I just want to say where is the line between a useful opinion and a opinion that can make a worse presentation?
Yes, that's a difficult question. I think you always have to stick to objective facts, and you have to use legal advocacy in argumentation, and you always have to show also knowledge of the sources, and you always have to be very respectful towards the work that has been done so far. So I don't think I have a straightforward answer to this, so that may be disappointing, but I think you have to always take into account the context also of your legal research, and when you are giving and for what purpose you are giving your own opinion, because your role as a researcher is to formulate a legal argument. So you usually say, I argue based on X, Y, and Z this. So before you make an argument, you have to provide certain hypotheses and sources in support of your hypothesis. So start with that, start defining this hypothesis, start looking for sources in support or of your argument, and then be aware of those against your argument and engage with them also, because your role is also to say, why do you think these arguments should not stand, for example. Is that what you meant?
Yes, thank you.
Thank you too, Emmanuel. So another context would be for literature review. It would be that you are writing your dissertation, and literature review is part of academic paper or certain dissertation, and it's very important to know that every academic paper is essentially written in a very similar way. They are all these styles of academic writing that are repeating different parts of legal writing, and usually you always start and should start the paper or dissertation by presenting the state of the art. So as Emmanuel also asked, and as I try to answer, you always have to first engage with the literature and say, I want to show you, of course you are not writing this, but that's your message, that you want to show the reader or the person with whom you're talking or arguing that you know and you have read and you have done your homework. So that's important. And then you have also the third context would be the review of practical know-how, where you mostly focus on rules, regulations, so practical solutions, toolkits, and you mostly engage with what has been done through professional journals, through the work of law firms and different legal research institutes and knowledge institutes. This context is also very important because it determines where you have to start doing your literature review. If you have an academic theoretical question, you always start in the library. If you have more practical question, you also go to the library, or you can also engage in different types of sources. So it all depends on the context too. What are you in fact reviewing? Depending on the context, you are reviewing scholarly work or practical knowledge, or both. This also depends on the topic. So for example, practical topic will always trigger both theoretical and practical knowledge. And my advice is to approach knowledge broadly. So try to understand, especially as I mentioned, that the many legal questions today are multidimensional and interdisciplinary. So approach knowledge very broadly, meaning that it's not only legal sources, but it's also how practitioners understand and read legal sources, meaning that you can also conduct certain interviews if you have time to get more understanding of this law in action rather than law in books only. How long should you do this, and how long should this literature review be as a product, but also as a process of reviewing? The literature is endless, always, on many topics. Probably people wrote everything on every topic already, so you could read and read and read and read. And whenever I always sit down and prepare literature reviews also for grant applications, when I have a new idea and I would like to submit a grant proposal, I'm always like researching, and then, you know, in the last minute you find something new, etc. So it's a very complex process and a difficult art to know when to stop and when you in fact have enough information. But first rule is to always address the literature that is pertinent to your own topic and puzzle. So focus, knowing exactly what you have to learn helps you quite a bit in understanding what literature you have to read. Of course, you can start with more general topics. And also, as Sarah Jane say, you can start to rephrase, etc. But I think it's important to be as specific as possible and read the main literature and then look for more potentially. It all depends on your time frame too. Of course, the more you read, the better, but you have to also be realistic and effective in your research. So spend some time doing preliminary research and then talk to people maybe around you to also help you with further guidance. And focus always on core sources, but also take into account those sources that may not be at the core, that may be at the periphery, because they sometimes say about new things that have not been part of the mainstream that may be quite interesting for you. Some practical tips. I would say look for and read other literature reviews. So have a look at the link I sent you, but also look for other literature reviews. Maybe they are shorter, more concise. Find a format that works for you and use it. Just write it down before your legal assignment so that you have a very clear overview of what has been written. Second, of course, decide on the methodology of this literature review and format that works for you best. Ask questions to your instructor, team member, a person from your team, or colleague students. Talk about it, because it can be also a very lonely process. If you work in a team, divide core topics of your assignment and compare preliminary findings. That's also a good way of having big impact or researching as many sources as possible. Another question is determine where will you look for this literature or practical knowledge. So knowing at least where to go, having two good databases or sources, that would be a good start. A good idea would be, which I always do, look for course descriptions or syllabi for core readings. So most course descriptions of master or bachelor courses are available online, not only from TUAS, but also from other universities, and they always concern core readings on specific topics. So recently I was writing a blog post on social capital, and I was interested in the theory of trust and social capital. And I'm not a sociologist, and I wanted a quick answer, so I looked through a syllabi on social capital course, and you can find quite a few, and you can find references that are to the core sources that you absolutely need to know. If you are reviewing practical knowledge within the legal field, get a grip of the legal regulation first. it's important to also know law on top of the sources that you are reviewing. Be always very critical regarding sources, especially those found on the internet. So don't cite to anything that you find. You really have to rely on reliable sources. And final practical tip here is that you shouldn't summarize every single argument that you read. Just be selective. Always remember what your main legal question is, what you are looking for, and provide a very concise summary on that, and then try to engage with the sources and maybe group them and determine sub-questions. Do you have questions regarding those practical steps? Do they sound useful for you, or is it something what you've been doing already, or some of them are maybe new to you? Gustavo, please.
Yeah, I find it really interesting, useful. I mean, this is no new, but of course, I think you will get better at this with practice. This is not like rocket science, but I think the tips are pretty useful, in my opinion.
Yes, and I would say that, of course, it's good to have a look at those practical tips, especially that you will have some moments of, of doubts, and going through these sources, it's very time consuming. I think it's important to have something at hand that you can refer to when in doubt, indeed. Step 3 would be to define the main research question and sub-questions, and this is relatively straightforward. The research question is your roadmap. It tells you what you need to find. So the way you ask about a legal puzzle very much determines what you have to do. If you have a very broad research question, if you ask a research question, to what extent is the Dutch government responding to societal needs in the field of health, nobody essentially knows, including myself, what I would need to look into. So this research question is, we keep saying about it, your lecturers or instructors, that it's so important, but it is indeed very crucial. And then sub-questions also must always lead to answering the main research question. So you have a main question, and then you have like smaller chapters through which you always have to respond to the main research question. And here you will also find some practical tips with references to the source. You have some tips regarding how to write a research question. It always needs to be very clear. It needs to be focused, concise, complex enough to attract, your legal research. So it shouldn't be a yes or no type of question, but some sort of complex question that has different layers of analysis at least, and it should be something arguable. So its potential answers are open to debate rather than accepted facts, for example. And this is always something to consider. And here you have some sample research questions, some of them being unclear, some of them being unfocused. For example, first question, how should social networking sites address the harm they cause? And the source that I'm citing here mentions that it is an unclear question. The clear question would be, what action should social networking sites like MySpace and Facebook take to protect users' personal information and privacy? So it's always important to be quite specific in what you are asking, because if you are very broad, you have to keep reading, keep looking, and it's usually impossible to answer broad research question, especially in a very short dissertation or legal product. The last step, and I'm rushing this a little bit, although it's a very important one because we have 3 minutes left. The last step is methodology. Methodology is as I mentioned, is part of a legal research that is always underestimated, and people just say, oh, methodology, I do desk research, that's it. And in fact, desk research means that you sit at the desk and you read and read and read, and this will be the most typical type of research, especially for the start. So there are different types of research, and I would be very happy to give you once the presentation and explain more about different types of research, like I included here in the slide, which is PAR, which stands for Participatory Action Research, where you involve members of the society and community and you do research together with them. But this is a little bit more advanced. I would say that for the start of legal research, you always focus on doctrinal legal research, so theoretical legal research when you analyze sources, primary and secondary sources, and oftentimes in a comparative perspective. So oftentimes the method that you use is comparative legal analysis. So you read different sources, you group them, and you compare them. And there are also quite specific rules for comparing legal sources, which I'm also happy to talk to you about next, or in the next meeting. So basically, the methodology that we are all doing in law is theoretical research, through which you try to understand rules, regulations, secondary sources, what has been written on topics, etc. And then you also have empirical research, which is mostly qualitative research. Empirical research means that you involve certain experiences, a law in action, so-called, in your analysis, which means usually interviews or surveys. For interviews, there are also specific rules how to conduct them. Most common are semi-structured interviews, through which you engage with professionals or people or subjects of your interviews by asking them questions, but by also leaving the discussion open and flexible enough so that you can also get some new information that you could not think about in your questions. And this empirical research is called qualitative research because you are looking at the quality, at the content. You are evaluating the content through interviews and also surveys. In more high rocket science, I would say sociological studies, you also use quantitative research methods where you do surveys and different other forms, or you use other methods to actually to understand the numbers, to compare the numbers. But that's a very rigorous, very strict type of research, and I wouldn't say that we lawyers who are not trained to do this know how to do this. So please remember, for the methods, it's really very important, because I read so many theses, so many professional products where students struggle with this. Two types of methods: doctrinal legal research, theory through legal analysis and comparative legal analysis, and also empirical qualitative research, mostly through surveys and interviews. Questions? Are there any questions in relation to the presentation, but maybe also something beyond the presentation that you wanted to ask and I didn't address? All right, so it seems that, well, I hope you found this useful. And if you have any questions, please do email me. I will share with you my email address, and I will also share with you the presentation. I will share it with Gustavo, who will share with you probably. And yeah, and please continue doing legal research and go through those hints and tips. They may sound totally basic, but it is really a framework that you have to keep doing and keep repeating, because it is really helpful, and the more you follow these tips, I think the easier it will be for you to conduct legal research. So good luck with your assignments, with your debates, and with all your legal products, and have a good evening.